Welcome to the Heart of Law podcast. My name is Mirena Umizaj, and I'm your host. Before I introduce my next guest and why I have invited him on today, I would like to take a moment to refresh on who we are, who is Mirena & Company, and what is our role in the legal space. And it will make sense why I have invited this guest and why we're focusing on this specific topic. Mirena & Company is a consulting practice to mass tort, class action, and personal injury law firms, providing financial and strategic expertise. Personally, I work with many capital groups around the country, including the world. Some are based out of other countries, which we'll talk about, raising money for my attorney clients and ensuring healthy execution of capital, steady scaling, and to ensure that firms develop a strong sense of business operation, especially when representing large segments of the population. With that said, my guest today is Jacob Cantrell. He is the co-founder and chief risk officer of Rocade Capital. Since 2015, he has led the firm's efforts in asset quality risk management and return optimization. Jacob has over 17 years of experience in the financial services and energy trading markets. He excels in providing technical direction to achieve effective credit and business strategy deployment while protecting enterprise value. He has successfully served in key executive positions at the Commission Exchange as its chief financial officer, where he focused on developing a new asset class in the deregulated power and gas markets, and also the EDF trading as its credit manager. Jacob also served as a vice president at a regional bank in Texas, where he created a loan review department, oversaw the credit analytics team, and worked closely with the board of directors to ensure sound asset quality was maintained. So very, very well qualified. Jacob, welcome to the Heart of Law. How are you?
Doing well, and thank you for that intro. It's always interesting to have it thrown back at me. I think I'm not in my 20s anymore, I think is the outcome of that bio.
Right. I do have those moments too, which is nice to talk about how much experience, but man,
Yeah.
does that really age you?
Yeah.
So as you know, Jacob, there are a lot of interpretation, because we're going to focus on litigation finance today. There's a lot of interpretation of what litigation finance means. After 10 years of working in litigation finance, I still come across law firms and attorneys that don't know what it means, don't understand its purpose. And there's a lot of misconceptions. So could you just tell me, what is litigation finance and how does it work?
Yeah, so at the risk of maybe going too high level, there's really three broad areas of litigation finance, of which my firm focuses really on one of the three. But to go through the three, you have what I would call, and what a lot of people think of if they're not in the industry, is sort of traditional commercial litigation finance. So that's where there's a single case, maybe a handful of cases. And there's the law firm, and it's more commercial litigation like IP, antitrust, international arbitration, things like that, where you have a case and a client that needs funding and money, and the law firm kind of pairs the client with a funder. They have a tri-party agreement, and off to the races. That's more commercial litigation finance. On the other end of the spectrum, and still not what we do, would be consumer litigation finance. So that's where the individual consumer, the claimant, the individual has a claim. And there are firms out there that will engage in financing that claimant's claim. And then where we're at, and what we have spent since 2014 really focusing on, is more of the loans to law firms, which is its own umbrella underneath litigation finance. But really the thing that ties all three of those things together is it's financing behind, for lack of a better word, a receivable tied to some sort of litigation, be it commercial, be it consumer, or be it to a law firm's, practice, where with contingent fees associated with which would be their primary asset.
Tell me why you got in the space. Obviously, you've got a really deep experience in finance. Why was this of interest to you, and how did Rocade Capital come together?
Yeah, so that's a really good question. So, for me, as you detailed out in the beginning, I really started in more of a regional or community bank environment, and the things that I really took away from that was sort of a purpose-driven help the community, help the businesses in your community, help the individuals in your community, and that really spoke to me. However, there wasn't a lot of opportunity for outside of the box thinking, right? So it's governed and regulated by the OCC or other regulatory bodies. Nothing wrong with that, but it really limits what assets you can value, how you can value them, what risks you can take. And so then that led me on to my next stop, which was EDF trading, which was energy trading. It allowed me to go a little bit further out on the risk spectrum to get a little bit of a higher return. Yeah. Created a synthetic utility and got to do all sorts of complicated fund structuring. But I felt like I was still missing a piece. And at the time, I couldn't really put my finger on it. But in early 2015, got introduced to this entire sector. I had probably read a couple of articles about it just tangentially, in my career, but I didn't really fully grasp what it was about. And, I came quickly to realize that this had the missing piece that I had sort of the first two phases of my career didn't fully put together. And that is, or at least not at the same time. So, I had the helping people in the community bank setting. I had structuring and really complicated, and I find that fun, like structuring and more complicated finance, but they weren't together. And here in this sector, I got to put all of that to use and fill in the missing gap, which was actually helping people and making a difference. And when I mean helping people, it's not just the law firms. It's sort of the pass-through benefit, right? It's the claimant, it's the harmed individual that has access to justice because there are law firms that can take their cases on contingency and can, get them either their day in court or their just, amount owed to them for the harm that was caused. And so, it's not often that you come, that a career option or path comes where you get to do what you're good at and also help people. So I really sunk my teeth in really, really quickly and, have been doing it ever since.
So tell me, obviously, because this applies to me, having it make sense, financial sense, because we all have to make a living, but also finding the purpose is incredibly important. So like the pairing is a very powerful combination. Mm-hmm. But if we were to just sort of stop at the financial piece, why is capital, and this could be a general question, not just your capital, the capital you guys raise, but why is capital so interested in the legal market? What do they see? What is the shiny object in terms of bottom line?
Yeah, I mean, not to give away any secrets here. So if I am, I guess I can take my lumps. But I mean, I think just at the sort of high level capital view, I think what's attractive is the non-correlated sort of return potential. And what I mean by non-correlated is the S&P goes up, the S&P goes down, markets go up, markets go down. Generally speaking, I mean, I guess nothing is ever truly completely non-correlated, but it's very lowly correlated, I guess, in that, the outcome of the litigation or the outcome of the cases, or how the law firm does financially is oftentimes not tied at all, or not closely, at least, to the overarching sort of market factors. And so I think just at a very high level, capital is always looking for some non-correlated opportunities. And I think that's the primary reason, at least at this time.
Yeah. And so for those watching, capital has entered the legal market for quite some time, but it has picked up steam, and more capital sources have come in to diversify their portfolios and have learned a lot about how the business works. With that said, there is misconceptions on both sides, and this is from my experience, as I said before, because I kind of sit right in the middle between the capital groups and the law firms. And so I find myself educating both the law firms and the capital groups, especially if they're new. What do you find to be some misconceptions about litigation finance?
It's a good question. So, I think from the capital side, sort of coming in and not really knowing it, is the barriers to entry are low. If you have capital, you can put it to work in this space. The barriers to long-term success are high, right? And I think that everyone has their own learning curve on that. But really, I think a misconception is being able to skip the part of really understanding the business that these law firms are in, how they make money, why they do what they do, and really just understanding it from tip to tail. How do they get cases? Where do they get their cases from? How are they working them up? How do they settle them? Who do they work with? What are their key co-counsel relationships?
Right.
And just really, really, really getting into the weeds and understanding just how the business works. You can't skip that part, not for long-term success. And then I think a misconception maybe on the law firm side is, I'm trying to think of just one, is, I think maybe it's the flip side of what I just said, which is maybe the expectation is that the capital, is it can go either way, right? They can be sometimes upset if they don't ask all the right questions, if they don't understand their business. You can go too far sometimes with some firms where, if you're asking too many questions, it's like, hey, I don't really want you to know, how I do everything I do. So I think just there's a little bit of growth in that relationship. And I think over time, a real differentiator and something that we spend a lot of time and effort, trying to hone is trust, right? When it comes down to sort of strategic partnerships, yes, it can be a lender-borrower relationship, but really the trust of sitting down, getting in a room, solving problems, and effectively keeping each other out of bad situations, right? So keeping the law firm out of a bad situation, but also keeping the lender out of a bad situation, and developing that trust over time. I've seen that lacking in a lot of, not directly with Rocade, but just as a sort of observer also in this space. I think there's a real trust problem between capital and law firms.
Yeah.
Primarily due to my initial statement of a lot of the capital doesn't take the time to understand how the law firms operate. And so with that, sometimes, breeds mistrust.
No, those are really, really valid points. And I think I have spent the last 10 years understanding the sort of the reasons why capital is, in play. Why is it important? What, depending on who are the personalities? Because I mean, at the end of the day, we forget we're humans, and that we're using the same instincts and sort of way of understanding how the world works and applying it to the day-to-day decisions that we make for our business. And so I think there is a lack of education, I think, in terms of what capital means and what is the purpose of it. While I think banks are used to using lines of credit for quite some time and understand that relationship with the bank, because third-party capital sources that are coming in, again, are putting forth these facilities that have non-recourse provisions and much less less strict provisions than a bank would, but they are making a lot more money than a bank would, that there is this feeling that the capital is viewed as sharks coming into the space. So it's been really interesting to see how that has started to shift, and it's been due to the conversations, to the transactions that have transpired. And I have seen, and the common denominator on law firms that didn't really execute properly was that there was really a disconnect between the capital, them, and having the conversations of how the capital would ultimately help the bottom line for both parties, right? So it's just that simple, right? So it comes back to what you were saying is trust, seeing it as a partnership, because you don't win unless they win, and you're supporting them, you're rooting for them. But at the same time, there needs to be some healthy boundaries, because they are also in charge of running the firm, litigating the firm, making decisions from that business legal mindset. But with that said, there is more of a legal mindset than business, and that business is still developing. It's still, I would say, in the infant stages in some ways.
Yeah, no, absolutely. And one of the comments that you made, and something that we've been spending a long time focusing on, and I think it's paying dividends now, and ultimately for our borrowing firms and strategic partners, something that I think would be helpful for maybe everyone to understand is, 10 years ago, this was a fledgling space, meaning, and in sort of risk and finance terms, that correlates to high risk, meaning we're not really sure how this is all going to work out, but here's some capital and I'm going to structure it probably really expensive, potentially overly expensive, because there's no real track record yet on how all of, the data isn't in yet. And some of these dockets can take, as we all know, years and years and years to solidify. And so, what we've done is spent the last 10 years solidifying that track record and really showing, how it's done, how it can be done, repeatedly and scalably over time. And what that does is it lowers our cost of capital, meaning the people that give us money, we can get access to funds lower and lower and lower, and we can then pass through lower and lower capital. So as if you think of it as the last decade is sort of proving it out, the next decade is for the firms that are run the right way and are doing things the right way. They can get access to, they can benefit from firms like us that have spent the time and effort really, structuring this in a way that has I think will benefit everyone over the next 10, 20, 30 years. So I think it has been a little high over the last 10 years. I don't think that that's representative of the overall cost of capital over the next 10 or 20 years. I do think there's a natural floor somewhere in here because risk and return are real. And these aren't, contingent fees as collateral isn't real estate. And it isn't, and my silly analogy that I use, right? It's not a warehouse full of t-shirts. It is a little bit more risky than that. So I think just from the tier of cost, it's probably always going to be a little bit more expensive than maybe alternative, businesses might be paying. But I think it will lower over time as the track record continues to grow.
Yeah. Can you share with our audience how Rocade is structured in terms of what types of loans, terms are available, and what is your ideal client?
Yeah, absolutely. So, we're generally, from a size perspective, that's probably most people's, that's one of the more common questions that we get. We don't have a cap on size. I say from 10 to over 100 million. We will go even below the 10. We've strategically gone below the 10, especially when, and this kind of goes back to the vision and everything that we were talking about in the beginning. Especially if it's a firm that has a really good story. They might be a little smaller, but they have a lot of potential and a lot of good things going for them. We've gone as low as 1 or 2 million out of the gate, for the right opportunities. But yeah, so from a size perspective, we can do anything. I think our wheelhouse is usually in the 30 to 50 million up front. That's where we like to be. We'll go lower, we'll go higher. Like I said, we've deployed over 100 million. And really our ideal law firm or client, it's a couple of things, right? So this might be throwing a lot at you, but it's growth focused or growth minded. So if they need to have a growth mindset, especially as you mentioned, the cost of capital is a little bit elevated here. So if you're going to borrow, slightly elevated cost, you need to have a vision. You need to have a growth mindset of what you're going to do with those funds. Client-centric, we want them obviously focused on their clients and representing their clients, fairly and well. That goes without saying, but it is part of the ideal sort of law firm.
It's a fair point, because we also know law firms that are not client-centric, that it's just a matter of aggregating cases and holding on to them and not really doing anything until hopefully there is a settlement. So I think both you and I have seen that. Yeah.
Yeah. So growth focused, client-centric, and then I would say leverages their data or sees the value in their data just as it's 2023, right? Just the value of effectively, that's what firms like ours are doing, is we're turning data into cash, right? So and obviously we do diligence and we spot check, and we're really looking through to the actual, agreements and whatnot. But I think that's a commonly undervalued process, I guess you would say, within a law firm. Is just, they kind of view the case management system as like a thing where you put some information in, but just really, really buying into their data and how to use it and keep it robust and up to date. And then really, and this kind of goes with growth focused, but it's not just, when I say growth focused, it's not just go add more cases, right? It's really investing in their people, investing in their processes, investing in their technology, and really having a vision to become a leader within their sector of the legal space. So that's our ideal sort of candidate is, if not all of those, a very large percentage of those.
Yeah, super helpful. I also find that because, and I sort of see, and it makes sense, because the legal profession it's a profession, that traditionally there's not been a business operation within a law firm. It's a very new phenomenon, right? Where you see now, ever since the advertising became possible, that lawyers are realizing I can reach more people, I can have more offices, I can expand my brand, if not in the whole state, in the whole United States. And so I think this business mindset and need is evolving within the profession, understanding that there is some growth pains and that most lawyers, as you and I know, don't really keep up with technology, don't really have the right processes in place. Again, because they are coming in as a lawyer and they're leaving as a lawyer. And when you grow, and you said this right, is when you have the growth mindset and you have the vision, that does not just encompass the legal aspect. Now it's, you got to think about potentially having a CEO, having a CFO, having different departments, making sure that the data is something you can track, because based on data, you can improve your internal processes. You can leverage your cases, which are your assets, for collateral. So you have access to capital and do it in a, disciplined way, have that sort of down pack. And now you don't skip a beat, right? And most of the problem firms I have encountered or I've had to come in and sort of step into has been really just keeping track and seeing how the firm performs over time, because now we can predict the future. So as a lender, obviously you are, you're talking to a lot of firms, you're learning about their business model, you're trying to get a sense, are they a litigator, active litigator, or an aggregator? And we know what that means. But sort of what do you identify why these law firms should seek capital, and it makes sense to enter into a partnership where you're advancing their interest and yours?
Yeah, so I may go backwards in answering those, but it is worth going down to the root. This could be an entirely separate podcast, but the root cause for the need of capital. All right, so and why it makes sense, but I will build up to why it makes sense. But fundamentally here, we kind of touched on this in the beginning, and I know a lot of this sounds cliche. So I won't lean too, I'll try not to lean too heavy into it. But, the real problem that we're helping solve is the average American does not have enough capital to access the American justice system. Meaning and I won't name names, but if a big multinational corporation causes harm, intentional harm, right? And this is a little bit of a tangent, but that is one of the things that we're focused on when we're reviewing these dockets is liability. It's the liability story and an actual bad act that has happened. And so, big company X causes a mass amount of harm. Well, if there was no contingent fee services available, can you imagine? You would have to go hire, the average American would have to go hire a lawyer and pay them hourly to go up against an army of, hundreds, if not thousands of attorneys on the other side, that they could make it drag out for 10 years and you could spend hundreds of thousands of dollars. So it's a very limited, they have limited recourse. The harmed party has limited recourse. What allows them to get access to the system, and like I said, that's a whole different podcast probably on the causes of that, but that just sort of is what it is today. And so what allows them access is that they have access to law firms that can take their case. I know everyone's heard it on commercials, right? If you don't win, you don't pay. But that's actually meaningful, where if they can actually hire an attorney at no upfront cost to themselves, and be part of a litigation against the company. Well, then follow that one step further. In many cases, the only reason that the law firm can take a case that they're having to spend real money, real time, they have rent and they have, employees and payroll and a whole big operation that's not free. And so one of the reasons that they can take those cases on contingency is because they have access to some sort of working capital from someone like us. And right. So, I think but that's I don't want to skip past the root cause here is an actually harmed individual that does not have enough money to actually, bring to task the company that harmed them. And then I think it just sort of goes from there. And then why take money or why borrow money from us or just in general? It allows you to help more people. It allows you to represent more people. It allows you to, I could get very, finance oriented here, obviously. It allows you to smooth out your ebbs and flows, your crests and troughs of your revenue, because say you don't utilize any financing at all, as you know, there's a lot of seasonality or cyclicality, if you will, in this, where you may have a windfall from litigation that you did 4, 5, 6, 7 years ago. But then in the meantime, or in the in between, you may be very cash light for for years at a time. And what that means is you can't sign up new clients. You can't represent people. You may know of a litigation. You may want to start a litigation. You may be investigating a litigation, but you don't actually have the funds to see it through. And so whenever you partner with someone like us, you don't have to make that decision. You don't have to sit on the sidelines while you're waiting for something else that you did 5 years ago to pay. You can really smooth out your revenue stream and allow you to be participating in the market that you're helping, that you're an expert in. You don't have to sit on the sidelines. And so I think that in and of itself is reason number one. And once again, not to lose sight, the firm is helping more people when they're doing that. Because when I say sitting on the sidelines, it means you're not taking a case, you're not representing someone, and you're ultimately not helping them.
When I first started working in litigation finance, this is around the BP oil spill era, probably right around when you started. It was interesting to see what the defendant was doing, knowing that the firms that represented the most amount of clients didn't really have any financial backing. And they knew that it was just a matter of time before they would collapse. And so I remember, and of course, as we know, the mass tort sort of area of law has evolved quite a bit, and it's grown substantially since the early days. But it really made it hard for law firms to fight the good fight, because they were either self-funded or they had a modest line of credit, and that could only take them so far. And if you had a docket of 30,000, clients, and you've got an operation with over 100 people, again, you're going to run out of runway very, very soon. So I think what it did, and this is where it all clicked for me and why I have been, doing it since, is that it leveled the playing field, right? It allowed, the lawyer that's working on a contingency, that's representing 10,000, 20,000, 30,000 people, to not settle for pennies on the dollar, to take them to court, to try 2, 3, 5 bellwether cases to establish a grid of fair grid, what the average case settlement should be. And it completely changed the tone. And so a lot of people saw the potential. But with that also comes, there's other things, right? With that comes the pressure of, okay, now I have capital, access to capital. I'm going to go out and get as many cases as possible. And then I'm going to settle them. And some of these law firms are not, are not working up the cases necessarily, right? They're just, it's like when I had Mark Lanier on the podcast, I think last year, he said you've got the chicken gatherers and the chicken pluckers, right? Mm-hmm. So, you've got all these aggregators who are not necessarily answering the phone, who are not necessarily talking to clients, and don't have the operation to listen to the stories. Some of them have never stepped foot in a courtroom before. How do you differentiate between the different kinds of business models? Like, what are some things that you identify quickly and it's something you pursue to take to the next level with that firm?
Yeah, no, and it's a great question again. So what I call it is part of our due diligence. What we're trying to figure out is where in the ecosystem does your firm sit, and what makes it complicated sometimes. And sometimes it's very clear one way or the other. But what does make it complicated is that it can oftentimes be docket by docket. So there are some dockets that the firm might be in leadership on and handling, and people are referring them cases. And then other dockets, they might be referring out, and they've gotten cases and they're referring them out. And so a firm can sometimes play different roles on different dockets. And so whenever it's sort of gray, what our job is, and what I think benefits the whole industry here, is we utilize our experience and expertise to sit down with a firm and really figure out what is their DNA, right? Where are they? Where are they at? Can they try cases? Have they tried cases? And look, we're really focused on good representation of the underlying clients. So said another way, if you are and I hate putting everything in either black or white, good or bad, because being an aggregator in and of itself is not bad. What we're looking for in that scenario is who are your key co-counsel relationships? Where are you referring these cases to? And we have come across some firms that have very robust co-counsel relationships, and almost all of their cases are actually being handled by firms that are in leadership in the litigations. And so that's actually a really good scenario in that case, and that the cases are being handled very well by very top tier, very capable firms. And so we do take the time though to sit down with the firms, and like I said, if they are more of an aggregator, my very next question is, who are your top 5 handling firms? Or who are your top 10 handling firms? Who's doing the work? And so if that next stage goes well, then we can keep the conversation going. So I think that to answer your question on kind of early indicators, that's one. And then really on the handling firm side, it's really, we're looking at the firm up and down, right? So everything, and we've been around long enough to know that there's no one right answer here, but you can, with enough triangulation, you can really get a good feel. But how many cases do you have? How many cases are you handling? How many attorneys do you have? How many paralegals do you have? What's your total staff? What's your this is sort of finance speak, but make versus buy. Like, are you doing all of the work internally, or do you have some strategic third parties that you outsource if you have a wave of things that you have to do on 5,000 cases? Are you handling that all internally? If so, where do those people sit? And, how many people do you have? If not, are you using another firm? If so, who? Because that can make a difference. So really just understanding how the work gets done and by who within a handling firm. And then something that I'm sure you've seen, and something that we've seen, is there's been a trend, and quite frankly it makes sense, but there's been a trend, and not that I agree with it, but I understand the trend of defendants really focusing on or trying to settle with litigation threats. So quite frankly, firms that they're afraid of going to court. I mean, you mentioned one earlier, this chicken pluckers and chicken gatherers quote, right? So plaintiff attorneys or firms that they don't want to see in court again. They've done it before, it didn't go well, and trying to sort of corner and settle and remove those chess pieces from the board, if you will. And so what that means is, does the law firm have a litigation presence? Have they been in a court, as you said? Have they been in court? Have they sort of made a name for themselves? Once again, though, not everything is black and white. So just because they haven't doesn't make them a bad law firm, right? It might be that they're a little bit younger. Do they have a trial strategy? If, are they going to bring in someone to help if they get a case picked for a bellwether? Or, do they have a plan? And do they have relationships with the people to fulfill that plan? That can be an okay answer. That can be an acceptable answer because you and I can't expect every single firm to be, a top 3 firm, right? It just doesn't make, that's an impossibility. But it's all about their connections and their plan, to deal with those potential, I don't want to call them shortcomings, but to deal with those potential, uphill issues.
Yeah. I think the business model that doesn't work for me, that I'm not going to get behind, right? And again, that's just from experience, is the business model where the law firm say takes $5 million, goes out and gets cases, and they sit on the cases. They don't have staff, right? They don't really do anything, maybe even wait for the last minute to get medical records if they absolutely have to, but they're really not on the phones. They're not working in leadership. They're not working with co-counsel. They're just saying, hey, I'm just going to hang on because I don't want to show my fee. And then you come to find out that at the end, when they're settling their cases, 60% of their inventory, they can't reach their clients, or the client signed with somebody else, right? The retention is very, very poor. And for whatever reason, because again, these cycles of torts have been going on for quite some time, I still come across these law firms, and I'm just like perplexed by that attitude or mindset. And I don't know if it's lack of understanding how it works or what the missing piece is, but I just don't think there is room for that. I think these clients need to be represented, and again, there is some right to, when somebody says, well, mass torts, clients are just numbers, right? That's because they are not talking to lawyers. They're not meeting with lawyers, and they do feel like a number. So it makes everybody else look bad in a sense. And I think there's a lot of room for improvement for those models.
Yeah, I could not agree with you more. So unequivocally agree. And we're not, if you come to Rocade and that's your business plan, we're not going to give you money. So sorry, but yeah, I mean, I totally agree. And I think over time, I do think it's all going to sort of work its way out. It's not a sustainable sort of business model, right? And I think, I'm not entirely sure why it has stayed around this long, but it's not going to work forever. I mean, it's really what I ask every time is, what is the value proposition of this firm in this space? What do you do, and how are you retaining value, right? Are you really good at obtaining cases and referring them to top tier firms to get to get quicker than average settlements and higher dollars? That's a value proposition if you're really good at that, right? And then are you a really good litigating firm and settlement firm, right? That's a value proposition. Are you really good at handling, working up, reviewing nurse records, kind of the middle part of the process? that's a value proposition, right? And so I'm constantly thinking of it in that way of what value are you putting into the system, into the industry, right? And if I can't answer that, then it's not a fit for us. And I think long term, I mean, I don't want to use the cliche term of disintermediation, but I think that what you're saying or what I'm agreeing with is maybe the forecasting of some disintermediation over the next 5 years or so, of where people that are doing that, I don't think they're helping themselves long term. I don't think they're helping their clients. I don't think if they do have financing, I don't think they're helping their financier. So yeah, I mean, I view that as, in the scheme of things, from an industry perspective, I view it as probably a short term sort of just working out the different business models that do work and don't work. And I'm with you that I don't think that one works.
Yeah. What types of cases or legal projects are you currently in love with? Like what is attractive? And also, we talked a lot about mass torts, but I think the personal injury world is also booming, and they're getting smart about how they transition into other practice areas. So I also want to be able to speak to that audience. Can you talk a little bit more about what's ideal within a PI firm or a larger tort firm that's handling mass torts?
Yeah. So what we've seen and what we're actively looking to onboard and partner with is really the combination. And it's easy to say, but I think it takes a specific kind of firm to be able to pull it off. And really, it's the combination of traditional PI or personal injury, and then more product liability, mass tort. And where I like the combination of these two things, and it's kind of funny because I sit on phone calls all the time, and there definitely is a bit of grass is always greener on the other side, vibe. And so the mass tort exclusive law firm looks across the fence and sees the PI, the personal injury shop, that's just burning out, revenue, their velocity of the cases, or the duration, if you will, of the cases is anywhere from 9 to 18 months, and the mass tort shop is just almost salivating at that sort of turnaround, right? But then you have the PI firm that's looking across the fence at these grand slams that some of the firms are hitting, from a revenue perspective, put in a lot of time, put in a lot of work, but then at the end of the day is sometimes a lot of money. And so, there's this fear of missing out sometimes on the PI side, looking over at those at the cash flow. And then there's the man, wouldn't that consistent cash flow be great from the mass tort firm? So combining those two under one umbrella inside of a law firm, and making sure that they have the subject matter expertise to do both, because it's not as easy as you can't just be a mass tort law firm and say, I'm going to do PI now, and then just put up a billboard. And it's a real operation that you have to develop a skill set to do, and then vice versa. You can't just get into a mass tort because you're really good at PI. I think that is a common, maybe not common, but that is sometimes, I think, a misunderstanding by some firms, is that, how hard can it be? And the answer is sometimes very. But anyway, so really building the firm of the future, right? Which is a balanced PI for the consistent cash flow, and sort of, the margins are more predictable, the cash flow is more predictable. Tends to be a high head count, a lot of work. It's not easy, but once you've really developed that business model, it's more predictable. It's more it's a quicker turn. But then pairing that with a mass tort practice that is that is focused on handling the cases, working up the cases, representing their clients, and really borrowing from the PI side, like the firms that I've seen that do it well, is from the PI side. One of the key things is what? Communication, and they're texting their clients, and they're really on top of it, and like bringing that over to the mass tort side, and then that pairs really well. But then there's still a need for capital, because you still have the growth mindset here, where you're going to have to add people, you're going to have to add expertise, you might have to add square footage to your footprint, to your space. You might add another city or another location, you might add cases. So really pairing our capital with our subject matter expertise with a balanced firm, I think in the future is, like I said, the sort of the law firm of the future in this space. And there are firms that are pulling this off right now. So I'm not saying that no one is doing it, but I think that business model, when done right, will outperform the other business models on the table, or the siloed business models. And then, from specific dockets, I'll back up a little bit here, and I try not to opine, to be clear, as the lender, and especially with our philosophy at Rocade, I will answer your question, but as the lender, I'm not directing anything of the law firm, right? I'm not telling them, hey, this is a good case, you should do this, or this is a bad case, you should not do that. To be clear,
yeah,
we're basically playing the role of the bank, right? Yeah. And so, sure, we'll have conversations on what we're valuing, or when we look at stuff, or things that we're hearing, in the market. But I'm not, it's not my place to direct, good or bad. And I've been around long enough to know what's bad today might be great tomorrow, and what's great today might be bad tomorrow. So, kind of taking that high level view. But, that being said, I can give you what we like structurally. And we're not, look, we're not risk adverse. We're not a zero risk, finance company here. We're not adverse to taking some risk. But, fundamentally, what we want, and this is going back to the mass tort side, it's not as applicable to the PI side, because, like I said, that's just more of an engine. Right. Obviously there are specifics, pre-lit versus lit, and how are they, what types of cases are they taking? But on the mass tort side, what we're looking for is sort of the post dispositive motion dockets to be the meat of what we're lending against. And because you don't want this might be counterintuitive to some law firms, listening to this, you don't want your lender to be too aggressive. You really don't, because, if they're just valuing everything at top dollar, and it doesn't work out, that it creates strain and stress and potential conflict between the law firm and the borrower. So you don't want your lender to be, zero risk and not take any risk, because then they're probably not going to give you any money. So striking that balance of sort of understanding, but not being too aggressive. And really how we strike that is we want to focus as much as we can. Once again, from a use of proceeds perspective, our firms are using it for, working capital, for growth capital, for debt consolidation. There's all sorts of things that they're using our capital for. But what we're basing the facility on, we try and have it be as focused as possible on what I would call late stage litigation, which is post dispositive motion. Common ones are, Daubert or preemption, or things where the defendant has a knockout punch. I try to think of it as the middle of the litigation, right? So in the beginning, there's all sorts of different steps where the defense can just get everything thrown out, and it effectively goes away. I know there are some examples where it can sort of matriculate down into state court, but generally speaking, there are some steps where it can go away. We don't want to we don't think it's healthy for your law firm for us to give you a lot of money based on things in that stage, just because it's still a little bit binary, right? There's still things that can go wrong that are unpredictable. Once it gets past a certain stage, things get a little bit more predictable. Obviously, things can sharpen over time when there's bellwether trials and things like that. But but we're focusing on sort of the later stage and sometimes even settled dockets where the settlement's already heard. But once again, as I'm sure settlement in this space can cover a lot of ground and time, from what stage of settlement is the MSA executed, have they reached all the thresholds, and then there's liens and all sorts of stuff that come into play. So it can be sometimes 9, 12, 18 or more months between settlement and payment. So once again, that echoes back to the first part of our conversation where you can kind of smooth that out. You don't have to wait for 18 months or 9 months or however long for those payments to come in. So I know I didn't give you an exact docket because I'm trying to avoid, leaning in on specific ones right now, but anything that's really post sort of dispositive motions are what we're looking to focus on. And like I said, that doesn't mean you can't use the funds to go after new ideas, new dockets. It doesn't mean we aren't tracking. We're paying very close attention to all of the litigations that are ongoing, and even some that aren't put together yet. So we're definitely paying attention, because we want to make sure that we're up to speed as those are making their way down the pipeline. That we're up to speed with the status of all those.
Yeah. No, that makes sense. I think I assume that, again, if you've got the trust and you respect a firm's track record and the vision for the future, that you trust their judgment in terms of what they're working on, what they want to get involved in the future. And I think that's a really healthy way of viewing it. That brings me to my next question, which is, can you be a little bit more specific about structure, cost, non-recourse? Like, these are the kinds of things when I start talking litigation finance to law firms, is how much does it cost? Is it non-recourse? Do I have to personally guarantee it? And how do I pay it back?
Yep. No, absolutely. So at a really high level, our product and a very common product in law firm lending, especially in mass tort, plaintiff law firm lending, is think of it like a traditional secured commercial loan, right? Like you would go to your bank, you get a loan. The structure is very, very similar at its core, in that it's commercial debt. Dovetailing the question into recourse, common question. So these tend to be non-personally recourse, meaning the partners don't have to, they're not on the hook personally. The lenders or capital in this space tend to utilize a bad boy clause, or I should say bad person. Sorry, it's 2023. A bad person clause that it's really to protect against fraud, right? I mean, it's you can't go and start another law firm with 2 commas and move all your cases over, and the lender loses all their money. So there are triggers just to protect from fraud, but they're generally non-personal recourse. It's just a commercial loan to the law firm, and they're paid back through generally a percentage of revenue that comes in. So think of it like money comes in and there's a certain percentage of it that gets pointed to debt to service the debt. Right. We to date, we have offered what's called PIC facilities, or they are repaid at the pace of collections. So there's not a cash pay component. We know some people have come into the space and, they need to have a cash pay component in order for whoever gives them capital to give them capital. We don't think that works in this specific space, just because of the need for capital like ours. Is because of this, not to repeat myself, but the cyclicality or seasonality of the cash flows make it a generally, untenable proposition for the law firm to have to pay interest every single month on their cash, every single month on their loan. So paid at the pace of collections, like I said, general cash flow split. Cost? Did you ask about cost?
I asked about cost.
So yeah, so cost is like we mentioned, it's a little bit higher right now due to most products in this space, including ours, are floating. And so ours are SOFR based. Anyone who's been paying attention, if you haven't been, I'll tell you, rates have gone up in the last year and a half. I think they've gone up about 5%. So that, that's just sort of a natural part of the market right now. I do think obviously eventually they'll go back down. So just over time, the floating will undulate. That being said, it depends on, the reason I'm giving you it depends is as you know, every deal is unique. Every deal is sort of bilaterally negotiated and put together, in a way, at least from Rocade's perspective. Our goal is to put together a product that works for everybody. We want the law firm wildly successful at the end of our transaction, and we've been repaid and they're very happy, and then maybe we can do it again, right? But anyway, so from a rate perspective, what we find works the best, we're not backed into having to do this, which I think is good. But what works the best usually is a dual note, an A note and a B note. And the reason for that, it's multifaceted, but one of the reasons for that is the A note is sort of the lower cost note. And so what this usually represents is an amount that's tied to kind of the settled or really close to cash. So the law firms tend to not like borrowing on something that they feel is going to pay in a month or 2 months or 3 months. And so, just structurally, we'll offer a lower cost A note that is usually paid off pretty quickly, just through settled collateral that's coming in. And that one right now is in the SOFR plus 10, 11 range. These are all, obviously for anyone listening, it's all very specific on the actual opportunity, but just to give you a feel for the ranges, you're at the S plus 10, S plus 11 range there. And then you have a B note, which is more of the growth capital note. And that's anywhere from S plus 16. You can go a little bit up from there. Sometimes you can go down from there. Really depends on the size of the firm. And, once again, maybe this goes without saying, but all of those rates, if the firm has $300 million in collateral and they're looking for $10 million, the rates are going to be as low as possible in this space. While still, as you mentioned in the beginning, firms still have to make money and operate. So we can't give away money for free, but you're going to get as low as cost as possible. Whereas, that same 300, if you have, 200 million in debt and you need another 50, or, if those numbers are a lot higher, the risk changes, the rate goes up. There's probably gonna be a lot more on the B, less on the A. So I know I'm not specifically answering the question, but from a range, that's about it. And really what I'm seeing right now is the cost of capital. So if you just break it down for the law firm, what they want to know is how much is this going to cost, right? And so there's always, and I know there's always other fees and commitment fees and origination fees. There are different fees associated. Everybody has them. And really, when you take out all the noise and you just look at the total cost of capital, what I see it averaging is, and this is a bit of a wide range, so but I think it makes sense, is between 18 and 23%. Right. It's sort of your range. You can go lower than that. Like I said, my example of 300 and wanting 10, you're going to be paying less than 18. You're going to be paying maybe quite a bit less than 18. And so, but that's sort of the most common all-in cost of capital range, is sort of within those bookends. I think and I think it can get lower over time as firms like ours, like I said, continue to sort of educate and perform on the track record that we've set down. So I do think that there is some downward mobility to that range. For where we're at as an industry today and the underlying risks that are being taken, I don't think that's an unfair range for a cost, especially when you're looking at what makes this all work is sort of the overall sort of profitability or return potential that the law firms themselves are having from the capital that they're borrowing from us.
Yeah. I guess to simplify this, because we are sort of speaking a language that sometimes people aren't accustomed to hearing or understanding. So if somebody has $10 million worth of cases, and I'm talking fees, not gross settlements, but they're expecting $10 million, and they've got a portfolio of 50% personal injury, 50% mass tort, where would they fall? I mean, I know it's different for every firm, but just a very generic, high level perspective on that.
From a loan amount perspective, like an availability?
Availability, yes, exactly. Like what percentage of their fees would you be comfortable advancing? Again, assuming they've got a good track record, they are litigators, they've got some cases cash flowing in 9 to 18 months, and then they've got these other torts that are bigger cycles, but substantial potential fees.
Yeah, so $5.65 million. No,
okay.
No, I gave ranges before, so now I'm trying to be more. No, honestly, it would be between 4.5 and 6.5 million, probably, depending on the composition of the mass torts, right? So if you said if all of the 5 was super early stage, that number is going to be a little lower, right? But if it's sort of the mix of a little bit of settled, a lot of late stage, and some early stage, we're generally in the 45% advance rate on what I would call late stage mass tort, about a 65% advance rate on a settled mass tort. And then PI, depending on the specific firm and the specific characteristics of their stuff, you're kind of in that range, probably closer to the 65 than the 45. So that was why if everything was at 45, you're at 4.5 on the 10. If everything's at the 65%, you're at 6.5 on the 10. So you're in, I know I gave a very specific number, but I was giving kind of a midpoint or around a midpoint between the 4.5 and 6.5. And then, the repayment on that, like I said, is sort of a cash flow split. We tend to go much lower on PI, anywhere from 25 to 40%, give or take, to debt on PI, just because of the fast turnaround on that. And then on mass tort, it's not exactly inverse, but it can sometimes feel inverse. I mean, there's more math that goes into it, but you're more in the 65, 70, 75% to debt on the mass tort. And so it would be kind of a blended repayment as those come in.
Right.
But yeah, so that's the, and then obviously the reason this works is you would take our, what did I say, 5.65 million. You would take our 5.65 million, and then you would turn it into more, right? You would go and either get more cases or make the cases that you already have more valuable, or, expand your operations. If you're talking about PI, you advertise more, increase your name recognition, maybe get into a new market. And so all of that then takes your 10. The reason that this works is that you start with 10, but then your 10 turns into 30, right? Because you're taking, or whatever the number is.
Sure.
And then you can borrow a little bit into that, and then a little bit into that. And that's how you can sort of scale and grow your business.
What percentage of the proceeds that you advance to the firm do you like to see going towards getting new cases versus the operation, the day-to-day paying payroll, paying the bills to keep the firm running? Is there any guidance or boundaries that you like to have there in place?
So it's a complicated answer, but as long as I know what the plan is, and I can model it.
Mm-hmm.
That's the number one thing. So if you say, look, we're really using this to just grow, to hire some more people. We've got a lot of we need a lot of more hands on deck, if you will, to handle the cases that we have. We're not really looking to grow right now. Maybe later. I can model. I can take that in and say, okay, I'm gonna assume minimal growth, and then I have to model it to where, or we have to model it to where everything works based on sort of the existing cases. So in that case, I might want to start out at a lower LTV, right? Because if I need to be a little bit lower on the LTV, because they're going to need to borrow up into that, but they're not really going to be adding all that much to the inventory. So I'm fine with that, right? Like I can make that work. Where it becomes
It can be
problematic,
beneficial to them to see
yes,
also, because the last thing you want is to, again, structure a debt in the wrong way, and then it affects everybody. It affects them
yeah,
and how they're
yeah,
executing. Yeah.
yeah, and so exactly what I like to see, and this kind of goes back to one of your earlier questions, but what I like to see is sort of processes, procedures, operations, all of that really ready to go and able to take growth before growing, right? Like, and so and obviously that can be a tricky line to walk. But I think where sometimes law firms get it wrong is, hey, I've got a lot of inefficiencies. I've got no real processes. I'm
Right.
barely hanging on here. So let's add 20,000 cases, right? And it's like, that's not gonna, it might work out, but that's, that's a very stressful way to grow. So I would rather step one be shore up the people, the processes, the technology, all of that, and then layer growth capital on top of that. I think where it becomes problematic is if the communication is, hey, I'm going to grow, and this is how it's going to work, and then you don't, right? That's where, if the model is a high growth model with then no growth, that can create some strain later. So I'm not showing favoritism over one over the other, or for one over the other. But as long as this goes back to the vision of the principles of the firm, and what do they want to, where does their growth mindset take them? And like I said, I think the smart firms are filling in, and we didn't spend a ton of time on this part, but I do agree with you. The CFO, the COO, the sort of the business of law, I think has been a long, it has been a highly neglected area in my experience. One that is getting better. I think people are getting the memo that these are areas that shouldn't be neglected. And like any business in any industry, I think the key to long-term success is surrounding yourself with people that are good at what you're bad at, right? And so the principals at these law firms tend to be, are the ones that we're looking to work for or work with, are great at law, right? They're great lawyers. They're great at, if they're trial lawyers. I could never do what they do, going and standing up in front of a jury and the cases that they're making. I mean, it's a skill set. These guys are great at it. Long-term capital planning and strategic, operations meetings aren't always covered in that skill set, right? And that's okay. I think, what I want to make sure is to sort of destigmatize you have to be an expert at everything all the time, or you're bad at what you do. And it's like, that's not fair, right? That's not fair for people to place that on themselves or others. And I think the firms or the principals that are sort of, I call it, knowing what you don't know, the ones that are really engaging in sort of a 360-degree analysis of their skill set. If you're brave enough to bring in the people to help you fill in the things that you're acknowledging aren't your strength, good things will happen, down the road.
Yeah. So the reason why I morphed into a consultant over time because I initially just started helping law firms look for the right capital. And I think there is a very important component of matching the right firm with the right capital source. So I put a lot of time into ensuring that, that the union, that the marriage is a healthy one, right? Because I also seen lenders that cross boundaries or treat the law firms poorly. I have seen law firms treat the capital poorly, as if, there is like this hierarchy, and the truth is it's really not a hierarchy. It's a partnership, and you both have to communicate, agree, have an understanding that you're headed towards the same thing, and that the script doesn't change. And if it does, you're going to communicate that. But I morphed from just facilitating capital deployment to a consultant, because I would see, after helping a law firm raise money, that they would sometimes take the money and dump it into the operations and pay the bills, because they were waiting for these long cycles of payments for cases to cash flow. And if those cases didn't cash flow on time, right, now they were out of capital, but they haven't raised or grown the inventory. The inventory was the same. So now you're asking to borrow more money on the existing inventory, and there's still uncertainty about timeline when those cases will settle. Obviously, this applies more to mass torts. But again, there's just like, mass torts, the shiny object, drop maybe trying cases every day, just go out and get a bunch of mass tort cases and then use that money to just simply pay the bills. Well, that doesn't work, right? And so the balance was, okay, let's develop the business at the same time as you develop the inventory, existing and new, have the right processes, technology, people, talent in place to oversee every aspect of the firm day in and day out. There is a heartbeat to the firm, and somebody needs to make sure that it's beating. And you get to focus exactly on what you said. If you're a lawyer and you like litigating, or you like a certain aspect of the profession, then you just focus on that. And so having those specialized, improved, optimized areas of the business constantly, measured and tweaked as your operation and inventory grows, I find that to be a win-win, situation. But also understanding, like, the different, as you expand as a firm, you can expand different practice areas as you expand inventory, just to diversify and to be able to mitigate your risk, to mitigate your lender's risk, so that your access to capital never stops. Like you said, the notes may be 2 years, 3 years, or 4 years, but if you're doing this right, that access never stops, and you can continue leveraging. So I became a consultant out of need, and really dove in deep to understand, to sit down with every department of the firm, and then really have a plan for all of them. So I've enjoyed that part, in fact, more than just the plain capital deployment, because it allows me to have the confidence to go in front of a lender like you and say, this is why I believe in this case or this client. I've done the diligence. We have a plan. We have the vision. And here's why I think it's worth taking a look. So I'm fully aligned sort of with everything that you're saying and the way you look at it. Is there, I know that we've run long because there's so much to talk about, but are there ethical concerns or potential conflicts of interest associated with litigation finance arrangements?
I mean, not from a law firm lending perspective, no. I mean, just the way we go out of our way to structure this, like I said, as a loan, our use of proceeds, literally, it's for business purposes. That's literally as vague as it gets. So we're not guiding anything. We're not involved in the litigation. We're not involved in the decision making. We're not involved in what cases they get, don't get. We're not involved in their intake criteria. I mean, we ask questions, especially on the initial onboarding, just so that we understand their business and how they're getting cases. But from an ethical perspective, no. I mean, we're not. I think where you see that being debated a little bit more vigorously is in the preamble, or in the question number 1 on litigation finance. One of those 3 buckets, the commercial litigation finance, where it's one case, one law firm, and one funder, and they've entered into an agreement where the funder gets 40% or 50, whatever the percentage is of the outcome. I know there's ongoing debates, not only here but in other in other countries, about how much influence does that funder have on that on that single case. I mean, the way we structure it is, I'm not repaid from any case, right? Like it's literally a general cash flow of the firm over a long period goes to service the debt. So there's no single litigation, single case that's sort of the repayment of our loan is tied to. So I think it would be a stretch to bring in any ethical or conflict of interest for our product.
As you know, there is no regulation yet. What are your thoughts on regulating litigation finance?
So, I mean, I'm always in favor of self-regulation in this space. So I think it's up to firms like yours and ours to set the sort of bar for best in class. And what I do think over time that capital, from the capital side at least, it will always flow to consistency and predictability. And so and I'm just kind of to get off track for 1 second, it always makes me laugh that there's this, and it kind of tied into your previous question, that there's this overarching criticism of all of these funders or all of this capital just loves financing non-meritorious cases that are never going to pay. And it's like, I've never met anyone in my life that wants to just throw money away, right? Like in something like this.
I know.
I think we actually serve as more of almost a gatekeeper. I mean, I hate using that term, but like really going through and reviewing the cases. We're spending a lot of time and effort and money and people reviewing the quantum and merit, or terms that you kind of hear thrown around in this space, which is the merits of the case, the merits of the litigation, if you will. And so I may have gotten off track there, but I think, from a regulation, I think I think it will regulate itself over time, because I think the people that are doing business the wrong way are going to lose money. And the people that are giving money to the businesses that are doing business the wrong way will lose their money. And so, over time, I do think it plays out. I still think there's a place at the table for, some self-regulation activities on just sort of setting the bar of what we expect and, who we will give money. I mean, we're already doing it for ourselves. I can't regulate other funders, right? But just who we choose to give capital to, how much we choose to give them. That is, in its own way, a little bit of regulation from our perspective on sort of the pace and flow of capital. Clearly, that's not everybody. So, other people can make the decisions that they make. I think and I know we're going long, but I think the 2 points that I don't think we've covered that I wanted to make sure we covered, that are, one is directly correlated, is, what I think for any law firms that are listening out there, that are thinking about this, and I think you would give them the same guidance, but what's really important is who is valuing the collateral, the cases? Is it outsourced to a third party? It's not inherently terrible. Some people are okay, some people aren't. But like we at Rocade, we do all of the work internally. We have master tort attorney on staff. He's great. We have people that we talk to in the space that give us, input, and we're the ones valuing it. We're the ones sort of owning that valuation and ultimately lending against it. So, there's not the third party said it's worth 10 and then 3 months later it's worth 5. And, there's all this, there's no control over the third party. So we do it all internally for that exact reason. Also, maybe this isn't a worry for some people, but when you send us your information, you send your information to the bank, it stays with us. Nobody else gets it. You're not sending it to a competitor. You're not sending it to another law firm. So just in the spirit of giving people things to look out for if they are thinking about finance, is who am I sending my information to? What are you doing with it? And who are you sending it to? Is it staying in-house? And just understanding where all the information is going. And it's the value proposition, but flipped on its head to us as a lender, right? What is our value proposition? Well, we are valuing your collateral. We are taking a stand on what it's worth, and we are giving you our money, right? And so we don't want to outsource that component. And then the other thing, and this isn't directly involved, I just want to land this because I do think we could go on another 30 minutes on this alone. But I do think that this has been, I meant to weave it in earlier to one of the questions or topics. I think a problem out there in the space, and I think it gives people like us a bad name, is a question you should always ask. Are you dealing with the decision maker? Are you dealing with the people that have the money? Mm-hmm. Because I think there's a lot of middlemen that aren't actually the lenders. There's a lot of, you know what I'm saying, right? I don't want to say brokers pretending to be bankers. I
come across them all the time, and it's like, just call yourself a broker, man.
Yeah,
you're a broker.
It's brokers pretending to be bankers, and there's a role. There's a role for brokers. So I'm not. But I think that does more harm than good, because then you pretend, you have firms that are pretending like they can actually do something.
Well, they're issuing term sheets.
And they're issuing term sheets, and then they're trying to get them filled. And anyways, so what separates us, and what if you don't call Rocade, which you should, or Mirena,
Mirena first.
Yeah. Then, but what these firms should be asking themselves is, am I dealing with someone that can actually make the decision, right? And, we've spent a lot of time talking about this, I know, but like sitting on the investment committee and running it and with my partner, Brian, and like, we are the ones making the decisions. We are the ones, approving and funding the deals and valuing the collateral, and, all of that is in-house. And I think that's the key to being able to be successful long-term in this space. So anyways, I know that both of those may not have fit directly into the last question, but those are things I wanted to make sure.
I think they're very valid points. I think, again, when law firms do decide, because they hear all of the noise about litigation finance, and I think a lot of people have heard by now, that firms are utilizing leverage and capital to grow the firm. How that works, they might not be privy to or haven't fully wrapped their heads around. But I think it's important for them to understand that when you're talking to people that say that they represent capital, or they have access to capital, or they are middle people between capital and law firms, it's really important to start doing diligence on exactly who is everybody, where they fit in, right? How long have they been around? What kind of track record do they have, right? And just do it just like you would take a case. You're vetting a case when it comes in the door. You're vetting a tort when it comes in the door. Do the same thing with business, right? Very much put the time, because all of that pays off, like you said, dividends later. And you don't have to deal with the headache of spending time with the wrong person, raising the wrong capital, the wrong terms. I think with me is when a client comes to me, it is my responsibility to go out and gather as much information and present as many options as possible, because I need to see what's out there. These mandates are changing constantly. The capital is changing constantly. The cost changes. So go out there, talk, see who is doing what, who's on the cutting edge, and then, develop the conversation further. And with that comes, let's talk about the business. Let's make sure we're in a good place before we even talk to a capital source, because you don't want them to see the pain points. You want to be able to have a good grasp on what you're going to spend money on without looking weak or like you don't know what you're doing. So it's a lot of strategy and thought process that goes into preparing, getting ready to even approach capital to ensure that you look confident and you're ready for that growth cycle. I do want to cover one last thing because, and this could be another podcast and likely will be, but we've only touched on debt structure here today. Mm-hmm. What has been emerging is equity structures. And there's a lot of capital sources out there that are doing equity deals. Yep. What that means, for those who don't know, is that now capital through Arizona, at least Arizona, sometimes DC, can join, with law firms, advance capital, acquire cases, and then share fees in the back end. The Arizona landscape is very new, so nobody's gone through a full cycle to see exactly how it works. What is your perspective on these new emerging joint ventures? Are you guys participating? Are you interested? Are you learning? Are you, tell me a little bit about that.
Yeah, no, so we're paying attention, very, very close attention. I think our DNA puts us in a wait and see sort of stance on the Arizona ABS front. We're definitely paying attention. I've read all the changes and updates, talked to a lot of people about it. I know people that are actively doing it. We're just trying to see where all of the, like you said, the kind of the whole cycle goes. So we're not actively doing it. It's something that's potentially interesting down the line. I think my 2 cents is that I don't think it's being used to its most efficient extent today. So today it's more, because from a finance perspective, when you say equity, I think cap table in a company, right? So an equity stance in a firm, which by the way, the Arizona changes allow for. And so I think to date, it's been utilized mostly for kind of marketing campaigns, sort of the lowest form. This isn't bad. I just mean sort of it's the simplest and easiest way to do it. Or, think of it like non-recourse book build, or, here's $10 million. You're going to acquire all these cases and I'm going to get, a fee or whatever. I think a more interesting thing is actually running it. Kind of dovetails into our earlier part of the conversation, where you can have a law firm in Arizona now with financial expertise, CFO, COO, business operations, paired with the legal expertise. And I think one of the reasons, to go backwards a little bit here, one of the reasons that a lot of law firms lack those areas is that in traditional markets, those people cannot own equity in the law firm. And if you're bringing in really high quality operators and CFOs from other industries, they're going to expect to have a piece of the company. They're going to expect to have equity upside in the firm as a whole. And so I think Arizona potentially down the line offers the possibility of just more of a robust equity structure that brings in not just the legal side, but the finance side. And right now I see most of it just doing like marketing acquisition and referring out to other people. Right. So I don't think it's being utilized where it will ultimately probably go. We're not active in it right now. It doesn't mean we're against it. It just means we're watching, and I want to make sure there's no. I tend to be a little bit risk adverse on regulation changes like that. I just want to make sure it doesn't get, you put a lot of time and effort and then it gets flipped back, or it has some sort of change to it that changed it. So we're not moving on that yet.
Yeah, no, I had Linda Shealy, the ethics attorney out of Arizona, on the podcast, and what she shared is that she doesn't think it's going to fly with, these funds coming in, getting the cases from an Arizona structure and then referring everything out, and nothing is being handled internally, right? You've got like a front desk receptionist just answering the phone in a physical location, but everything is being done remote outside of Arizona. So she thinks that's going to be an issue. And rightfully so. I mean, if you're going to do it, I think you should put the time to truly develop the firm and bring in, like you were saying, like people may not be getting paid very well up front, but they've got a piece and they're all working together, bringing their expertise to get projects to the finish line. So I think it could work if done right, just like anything else in life. But no, I appreciate that. And again, look, this is an evolving area. It's evolving so fast. There's so many new capital sources coming in the space. And the mass tort world is changing. One thing that has, for me personally, I think throughout this entire process, the major takeaway is that we could truly go after meaningful social causes, not just defective drugs, not that those don't matter, or that they're not important. Of course they are, but there are so many areas that I think need attention, need the legal talent and resources to truly make an impact in the system, in the country, in the economy. And I do think that if, getting creative as a lawyer, and gosh, some of the lawyers that, some of the MDLs, the biggest MDLs, were small town lawyers that were not big operations, right? And those are the success stories. And so I don't think, anybody should underestimate what they can do or spark a movement or take on that case that will lead to a massive social change. And I would love to see capital get around, figure out how to help those firms that are very under-resourced, that truly are working for the right cause and, need the capital early on, maybe not a massive facility upfront immediately, but enough, because again, it's a risky game, but enough to spark that fire and cause it to take off. And I would love to see more of that. And I know you guys are doing an amazing job. I like everybody at Rocade Capital. So keep up the good work. Truly appreciate your time today. And I'm sure we'll be talking again about the next chapter in litigation finance.
Yeah, no, absolutely. And thank you for having me on. This has been a good conversation.
Yeah, thank you. Thank you, Jacob.
Stay tuned for upcoming episodes available on popular platforms such as iTunes, Spotify, and YouTube.